I'm Cecil Mills. I'm the Deputy District Attorney General for the 3rd Judicial District. That covers Greene, Hamlin, Hancock, and Hawkins counties in the northeast area of Tennessee. I fell in love with a show that I don't think lasted on television 2 years, Judge for the Defense.
Judge for the Defense.
And it won me over. I love trial practice. I love feeling like I'm doing some good for somebody, and I believe I'm an advocate. That's how I kind of classify myself, but I love trial work. Well, a preliminary hearing is the first check to verify whether or not the state of Tennessee has enough proof against a defendant for a case to go forward. It is generally heard by a General Sessions judge in General Sessions Court. The state of Tennessee is required to prove that it has enough evidence to show probable cause that a crime was committed and that the defendant committed the crime. That's why it's frequently referred to as a probable cause hearing. Typically, the state calls as few witnesses as it can and puts on just enough proof that it can to meet that probable cause standard for the court. The defense at the preliminary hearing is able to cross-examine the witnesses we call and to examine the evidence and question the evidence that we present, and also to call witnesses itself if it desires to. We try to keep the defense from knowing everything that we have, even though we're going to be turning over to them later. But we would like to develop the case and just build as we can before turning everything over to the defense counsel. We understand that it can be uncomfortable to testify against persons that you are related to or care about a whole lot. Sometimes, however, that scenario cannot be avoided. I do want you to know that we work with every witness to try to make them feel as comfortable as we can. We have an awesome duty as prosecutors. The duty is to present proof. We're called upon to uphold the law, and in upholding the law, we have to prosecute people by holding them offenders accountable for what they've done. That means sometimes we have to call people who care about the defendant and are related to the defendant. We do everything we can. And I'm looking back over 37 years experience, and I know it even for the younger assistants. We do everything we can to try to work it out, to figure it out where we can work together with each witness. If we're unable to do that, we're able to call a witness as a hostile witness. If we call that witness as a hostile witness and they still refuse to cooperate with us, the court can find that person in contempt of court and actually order fines and jail time as a consequence. Generally, we ask questions of a witness that they have direct knowledge of, such as what they saw, what they heard, even what they smelled. Almost all the 5 senses. We ask them what they observed at a scene, what they observed take place, and then what they did as a result of what took place, what they saw and observed. Some witnesses are able to testify about having come up on scenes and what they observed. And then, of course, you have other testimony as well and other evidence as well. Some is irrefutable evidence, things like video recordings, medical records, lab reports. cell phone records, those kind of things are generally irrefutable. But then you also have testimony, and I think every lawyer's been through it, every prosecutor's been through it. It's not so explosive. Sometimes can be a little more, I guess, boring, but it's important. It's technical evidence that we have to get into a trial to support the case that we're presenting against the defendant. Well, one of the tests that we give in preparation is I ask people, did they eat breakfast this morning? The answer to that simply should be yes or no. But in the preparation for a trial, some people go on and tell me whether they had bacon or eggs and ham, and I let them go on and I smile and then politely tell them they made an F on the test, and then we go back and we ask the question again. It's natural for us to want to fill in the blanks. That's a natural human tendency, especially if you've got a lawyer just standing there not responding. But once you've answered the question, once you understand the question, just stop. We try to prepare our witnesses for cross-examination. Generally, there's a rule. It always starts with the truth. You always start with the truth. I can deal with the truth no matter what happens in the case, but you always want to make sure that your witness has listened to the question, made sure they understand the question. And if I may add, I deal with that a lot with witnesses because they think if a lawyer has asked a question, surely it was an understandable question. Sometimes it's not. And I make clear to them that if they don't understand it, no one else in that courtroom probably understood it. Make sure they understand the question and then answer only the question they have been asked. That rule will generally make it easier for the witness to be cross-examined. Also, a witness needs to know that when they've been cross-examined, the prosecutor usually will have the opportunity to come back and direct a redirect examination where we ask them questions. We can gain additional information from them and also clarify anything that may have been misunderstood by those who were listening. It is necessary. In the preliminary hearing type stage that we are talking about now, I will admit that we do everything we can to try to avoid that situation. It's not always possible. In those cases, prosecutors will work with the victim. By that I mean we listen to their story, let them know the support they will have. And yes, it's tough. It is heartbreaking. But we will do all we can to help that witness feel comfortable. It is a basic tenet of criminal law that a criminal defendant has the right to confront their accuser. If we call a witness to the witness stand, that attorney is going to have the right to cross-examine that witness, and that defendant will be in that courtroom. Some witnesses want to ask me, will the defendant be in the courtroom? And I have to tell them yes. Their attorney will probably be the one asking the questions, but yes, that defendant will be in there. The defendant has a constitutional right. There may come a time when I ask that person to point to the defendant who has committed that offense against them. That is the only little sticky point. There may come a time when I ask them to point out the person who did that to them. Dress like you were applying for a job. We always start off by saying, be neat, dress appropriately, Don't wear a shirt with sinister on it or something like that. But more importantly for me, it's just a very simple thing. I think we prefer that witnesses dress conservatively and professionally. The things that we deal with in court, it's more unbelievable than what you see on television. It's real life. It's people that are hurting. If I may say it, on both sides. You've got family usually on both sides caring for the victim, and then you see the family caring for the defendant. It's real life. And as a prosecutor, we feel a special responsibility because I think most of us believe and do feel in our hearts that we're representing the people. I know that defense attorney feels the same responsibility, that he's trying to protect his defendant, zealously defend his client. And so yes, it's real life, and it's in court that you see the real tears. It's in court you see the real hurt. In court you have to deal with victims that you cry. You can't just leave it in court. You try to, but it goes with you.